members.
Mr. Miller, timing.
Timing, my lord.
We think that the appellants collectively should be strongly encouraged to finish by the midday adjournment tomorrow, but to assist them on their way, we would be prepared to sit half an hour early. That would, between you, you would have to find an extra half hour on that basis. That should be possible.
I hope that's possible. As far as we're concerned,
there is a good deal of common ground.
Your Lordship puts it more felicitously than I would have done.
And on that basis, the respondent will then have an extra hour. But again, you must, I'm sure you all will take it that we have read the very full and helpful cases.
Very much obliged. My Lord, I appeal with my learned friend Mr. Nolan and Mr. Beard for quantum, as I'll call them, the first appellants. Mr. Purchase, Miss Foster and Miss Whitaker appear for the second appellants, Meridian. My learned friend Mr. Lim and Mr. Stewart appear for the third appellants, Pretty Polly. And Mr. Kent and Mr. Williams, my learned friends, appear for the intervener, Guy Warwick. And arrayed, as it were, against the ranks of Tuscany, one has for Mrs. Baker, Mr. Hendy, Mr. Huckle, and Mr. O'Leary. My Lords, the decision of the Court of Appeal against which this appeal was brought was to the effect that the first appellant, whom I represent, could be liable in damages to an employee who had suffered hearing loss arising out of exposure noise levels at her place of work for a period of 12 years of 85 to 86 dBA length, the unit of measurement, and in so doing it departed from the previously accepted threshold for a case such as this of 85 equivalent dBA, which had its solid foundations in our submission in jurisprudence, including 2 decisions of the Court of Appeal itself, in commentary, including 3 specialist authors, in the 1972 Code of Practice, which held sway at all material times, and in the practice and expectation of employers and insurers alike. It will be respectfully submitted that in departing in this case from this standard in the general run of cases, the Court of Appeal has wrongly indulged in retrospective judicial legislation. It required by its judgment the achievement by January of 1978 of a level of hearing protection which regulation did not require until the Noise at Work regulations of 1989, which came into force in January of 1990. Indeed, it set a higher standard than those regulations in requiring the elimination of all risk to hearing, whereas the regulations themselves contemplate some residual risk even with full compliance. It imposed, in short, we would submit, the standards of the 1990s and beyond on the practices of earlier decades. It reached what we contend to be a wrong result by misconstruing the relevant legislation, the Factories Act of 1961, and by, without any justification, substituting its own view of what constituted a breach of the well-established common law duty owed by an employer to his employees, and overriding, in that respect, the trial judge, who had had the advantages traditionally enjoyed of seeing and hearing witnesses, both expert and lay, and whose appreciation of the evidence before him and the conclusions to be reached on it could only properly be departed from by an appellate court if flawed by some obvious error. It engaged in precisely the exercise against which 2 members in particular of the Court of Appeal advised in the Maguire case, and it did so even though, as is common ground, the science itself had not changed over the decades with which the Supreme Court is concerned. Can I take you right away to the Maguire case, which is in bundle 4 of the authorities' bundles at tab 70. It's a case in which my lord in the chair will be well familiar, having been a party to that decision, and although dissenting, was dissenting as we understood it on issues of fact rather than on the proper approach. And can I take you firstly to what was said by Lord Justice Longmore at paragraph 96.
Sorry, which is the tab again, please?
Tab 70, okay.
Is there an index to all the authorities
There
in
is.
a bundle?
It's
Is it a separate bundle?
It's at the back of of core volume 4.
Oh, thank you.
What Lord Justice Longmore said was this: the courts should, in my view, be careful before they impose in a scientifically developing field standards which no employer ever thought of adopting at the time of the occurrence of the injury complained of. Exposure to asbestos dust is a classic case where knowledge and awareness of disease advances incrementally. Industrial deafness, of course the subject which the court is today concerned, has been shown to be another. One might also instance lung cancer allegedly attributable to passive smoking. It took a long time in the history of association between smoking and lung cancer for it to be appreciated that it was arguable that lung cancer could also arise from passive smoking. It could hardly be suggested the employers should have appreciated the danger as soon as they appreciated that lung cancer could be attributed to the inhalation of tobacco. And Lord Judge, to the same effect, at paragraph 21, your Lord should be kind enough to go back to that paragraph. Perhaps the starting point is a broad generalization. When considering criticisms of actions and omissions 40 years ago, we have always to warn ourselves against the wisdom of hindsight and recognize the potential unfairness of using knowledge accumulated during the last 40 years, which by definition was not available to the defendants. It has taken a very long time indeed for the true extent of the dreadful risks posed by exposure to asbestos dust to become known. As we shall see, the learning process has been gradual, beginning with those most obviously at risk, employees whose work directly involves such exposure. Mr. Justice Morland himself accepted that there was nothing in the specialist safety, medical or factory inspectorate literature to alert Harland and Wolff to the risk of secondary exposure. That finding is unchallenged. Quite apart from the absence of any warnings of familial risk in the literature, Mr. Clark was unable to identify a time prior to 1965 when, as a matter of prudent practice, careful employers began to address the danger of asbestos-related injury in the family of their employees. There's no evidence in this case, none in Gunn, which suggested that prior to 1965, the risk described by Mr. Justice Morland as obvious gave rise to any echoing concern among responsible employers for the safety of members of the family of employees who work with asbestos dust, or indeed among those with wider responsibility for safety and health generally. And we would respectfully submit that the Court of Appeal in this case ignored those words of wisdom. My Lord, I said at the outset that this was a radical departure from the accepted position, and can again, and I wish in view in particular of the pressure on time to be as sparing in resort to authorities as I can, but I should take your lordships to the recent case, only 5 years ago, of Harris and the British Railway Board, which your lordships will find in the previous volume of authorities at tab 52. And effectively, what was recognised in this case by the court was that there was a threshold, the 90 dBA threshold, in what it termed the general run of cases. And again, taking the matter as expeditiously as I may, I start by paragraph 11, where one sees reference to a very useful small book written by Judge Macduff, Queen's Counsel, now Mr. Justice Macduff, on the subject of claims for industrial deafness, a practitioner's guide. And one sees again that in the first sentence, it is well established well established that the watershed between risk and safety is defined at 90 dBl LEC, and then to like effect the balance of the paragraph. And the Court of Appeal, the Lord Justice Newberg, as he then was, says, in the light of these observations, it's scarcely surprising the defendant's case below and repeated here is that 90 dBA LEC is the watershed or threshold which should be adopted, and the 85 dBA LEC threshold for which Mr. Harris contended and still contends should be rejected. One may then go forward to paragraph 23. Lord Justice Newberger says, as I've already explained, so far as the first issue, namely the existence of a duty of care, is concerned, the normal level of sound which gives rise to a duty of care in law is 90 dBA LEC, and Mr. Harris's case was based on the proposition that the defendant owed a duty of care to him on the basis the level of sound was over 85 dBA LEC, but below 90 dBA LEC. That's the very area within which the Supreme Court is concerned in these appeals. And then he goes on to say that the way in which it should be catered for was protectors. Then if we go to 36, Mr. Leighton Williams, who was there appearing for the respondent, the defendant, the British Railway Board Residual Limited, says the defendant has no quarrel with the conclusion in relation to Judge Macduff's book, since it's always been accepted that exposure to 85 dBA LEC gives rise to a foreseeable risk of injury in the broad sense that all excessive noise is potentially injurious to hearing. However, as he went on to say, the mere fact that a particular level of noise is sound is potentially injurious does not of itself give rise to a duty of care. As he put it, the existence of a duty of care depends not merely on forcibility, but on whether it's just and equitable to impose the duty. Whether one respects that formula or otherwise, it is said that foreseeability is a necessary but not a sufficient basis for the imposition of the duty, and in that way we would adopt what was there said. I do not understand Mr. Hillier to quarrel with that formulation, which appears to me to be not only sensible, but correct as a matter of principle. However, once one bears in mind the accepted fact that the 85 dBA LEC level of sound involves a real risk of damage to employees' hearing, it seems to me plainly to follow it must ultimately be a matter which is capable, on the particular facts of a particular case, of leading to the conclusion that the exposure of an employee to that level of sound can give rise to a duty of care. And then he qualifies this by this important paragraph. That observation is not intended to call into question the applicability in the general run of cases of the 90 dBA LEC threshold. While each case must turn very much on its facts, not least because of the just and equal test accepted in the advancement of the defendant, it's appropriate that there should be a generally applicable standard, albeit the standard must yield on occasion to the particular facts of a particular case. And then he gives a rationale for that. The existence of a general standard enables employers and employees to know where they stand in most cases, and therefore it reduces uncertainty in the costs and pressures of litigation. He then goes on to refer to Judge Macduff's remark and to the code of practice and to certain consultative documents which also feature, as my lords will be aware, in our printed cases. He then refers to the classic judgment of Mr. Justice Swanwick in the Stokes, Guest and Keane and Netterfeld's case. Again, that's something I shall need to return to at the conclusion of my submissions. And then he says at 41, it may well be a good working approach that the 90 dBA level gives rise to a presumption. If the sound is above that level, the owner shifts the employer to show why he should not in principle be held to be negligent, whereas if it's below that level, it's the employee to show why a duty should be posed at all. I do not have a wish to be interpreted laid down any rule or principle. The best what I have in mind is a rule of thumb, but it should be emphasised that even putting it that way, I'm proceeding very much on the basis of the evidence, arguments developed for us. And then at 757, it's essential to remember this is an appeal in the normal way, namely by way of review. The question for us is not whether he reached the same conclusion as the judge, but whether he reached a conclusion that he was entitled to reach. That again features when I come towards the end of my submission, so the appropriate approach to a finding of a judge of 4 seats in the appellate court. For the reasons given, I have no difficulty in holding that he was entitled to reach the conclusion he did on what he identified as the first issue. In the light of the totality of evidence in this case, it appears to me that while in no way seeking to suggest that in the normal run of cases the threshold or watershed should not be regarded as 90 dBA lek, the judge was on the particular facts of this case entitled to reach the conclusion the somewhat lower threshold of 85 dBA lek was appropriate, and that was because of the degree of knowledge, etc., that was attributed to the particular defendants in that case. So that's one and recent case in the Court of Appeal, which is diametrically opposed to the conclusion reached in our case. And just for your Lordship's note, there's also a decision of 1995 in the Court of Appeal, the case of Barrand, which is in Volume 1, Tab 10. And I just give your Lordships, if I may, the references 10G to 11B and 12B to C, the leading judgment being given by Lord Justice Glidewell. So one had two relatively recent cases at odds with the way in which the Court of Appeal determined the present case. Can I also just give you references, again, in order to avoid unnecessary elaboration, in our written case at paragraphs 67 to 69, we have noted that at first instance judges, there has been a constant recognition of the standard of 90 dBA lek in other than exceptional cases. The cases that we refer to, and your Lordships have the references in those paragraphs, of the Thompson case, the seminal judgment of Mr. Justice Mustill, as he then was, in Baxter and Harland, a decision of the Northern Ireland Court of Appeal, in Kellett, a decision of Mr. Justice Popperwell, in Taylor and Fazackley, a decision of Mr. Justice Rose, as he then was, and two other examples that I cull from the reports in the bundles, which you could add to that list, a case called McIntyre, a decision of Mr. Justice O'Connor, as he then was, bundle references 5, Volume 5, Tab 77, and Carragher, a Scottish decision, Bundle 8, Tab 5. So there was, again, a consistency of approach, both north of the border, south of the border, and indeed in Northern Ireland as to the appropriateness of that standard. So that's the jurisprudential status quo.
Mr. Belford, did the Court of Appeal address Harris in particular?
My Lord, they did address Harris, but...
They did or did not?
They did address Harris,
yes.
yes.
Oh, well, no doubt we'll come to it.
Yes. Academic, again, can I, again, for shortness, just give you the references? Monkman, which we do quote, the standard work on employers' liability, the 13th edition in Chapter 7, edited by Mr. Brian Langstoff, then Queen's Counsel, now, of course, adjusts the High Court, at paragraph 790. This is in volume 11, tab 23. I'll just quote for the record what he said. In practice, a claimant thus has to prove that the claimed industrial noise exposure prior to the 1989 regulations coming into force on 1st January exceeded the standard set out in the 1970 code of 90 dBA lek. And then the second illustration is Mr. Justice Macduff, cited in the Harris case that I just gave your Lordships the reference at paragraph 11 of that judgment. And the third instance of academic commentary is by a Mr. Grime, who wrote a specific specialist work on the law of noise-induced hearing, which you have in your bundles at volume 12, tab 14, and at page 1, and indeed at page 7, he repeats what is, as it were, the standard view.
That's Stephen Grime, QC, is it?
It is not, in fact,
No.
Stephen Grime. No, it's Mr. R.P. Grime. I was under that misapprehension. Having had the privilege of teaching Mr. Stephen Grime, I'd have been particularly interested had it been him, but it was not. Now, in practice, this is, as it were, my third head. One needs to go then to the judgment in Core Bundle Volume 2 of the learned judge His Honour Judge Inglis, who laboured, as one sees, for 18 days in this particular vineyard. The judge at first instance judgment is at tab 6, and he deals with this matter at paragraphs 46 through to 48. And one sees, if one goes to paragraph 46, he's describing the general approach to noise in the industry. And again, I'll try to summarize, if I may. The state of understanding the individual employers involved in this case will be looked at below, and then he refers to various experts who gave evidence. And he refers to a Mr. Bramer, who was an engineer for portholes, who said that the guidance in the document Noise and the Worker, the 1972 guidelines, provided a clear and consistent recommendation to employers as to how they ought to deal with noise in the workplace. That's the basis upon which he advised. 4 lines in, he says this approach was standard during the period up to 1989 among noise professionals and taught at training courses. And he goes on to say that, that the advice he would always give would be to comply with the legislation and the code of practice, rather than to say, tell me how to avoid reasonably foreseeable risk to my workforce. He'd have recommended 90 dBA as the cut-off point, but would also have said that does not actually stop some more susceptible people from having some small noise-induced hearing loss. So that's, as it were, what was the evidence about the advice that would be given. At 47, he deals, the other witness deals with the health and safety executive and factory inspectors after the 1974, the well-known Health and Safety at Work Act, and he says they concentrated their advice and enforcement on the 90 dBA level. So that's, as it were, the second segment of the constituencies involved in this area. And to like effect was a report from Mr. Worthington. So it's what the judge then says, it is clear from some of the documents referred to above that by the beginning of the 1980s there were still many people employed in the industry exposed over 90 dBA, and that the approach of the enforcement agencies was to concentrate on those people. The evidence the engineers above referred to that suggests that was the common approach until at least into the mid-1980s. And then he refers to a seminar that was given at the University of Southampton by the Wolfson Unit for Noise Vibration Control in 1976, and one sees the quotation from the notes at the foot of the paragraph. The notes, he says, are therefore the strong evidence, the prevailing advice being given to people in industry concerned with noise at that time, a reference to the 1972 guidelines, etc. And then in the discussion of the emerging principles of legal liability for noise-induced hearing loss, the authors say this: over the last 15 years, knowledge as to the relationship between noise and deafness has grown and become more precise. Today, a reasonable employer ought to know that to expose an employee to noise in excess of 90 dBA for 8 hours or its equivalent is potentially hazardous. It also seems a fair assumption that the reasonable employer would have known of the criteria set out in Noise in Factories and Noise in the Worker by the mid-1960s. So again, one sees employers, the inspectorate, and the advisors, all in our respectful submission, taking that, the limit, the hallowed limit of 90 dBA as the touchstone of reasonable standards. And finally, I'd like just to show you the Health and Safety Executive Consultation Paper that one finds in volume 4 of the core bundle at tab 19 and paragraph 7. This was a consultative document published in 1981. And at paragraph 7, and this again, of course, at paragraph 7, tab 19, my lord, core bundle Core Bundle 4. This is the general duties section. The general duties sections of the Health and Safety at Work Act 1974, which is, with respect, clearly in advance and meant to build on the Factories Act 1961, in effect requires employers and others to do all that's reasonably practicable to protect the health and safety of persons at work. In interpreting these requirements in the noise field, inspectors of health and safety, to whose work, incidentally, Mr. Justice Masterson then was paid special tribute in the Thompson case, used the guidance given in the 1972 Code on the levels of exposure which are regarded as a serious hazard to hearing and on the action which should be taken to protect workers. And then he goes on to deal with 4 sets of regulations that have made more precise obligations in particular areas of activity. The implications, obviously, in our submission of the decision in the respondents' favour of a retrospective lowering of the threshold for liability are considerable. We spelt it out, if I could just give you the reference in the petition on the basis of which we received permission to this appeal in Core Bundle Volume 1, our petition at page 3, paragraphs 4 and 5. The claimant solicitors, which we there quote, themselves say the case will affect tens of thousands of claimants. If the Court of Appeal be right, the courts will in future be required to inquire into events which took place at times ranging from more than 3 decades ago, back to 1978. It will subvert, in our submission, the basis upon which employers' liability insurance arrangements be made, as they will have to meet a liability that they could never reasonably have foreseen at the time policies were written and premiums paid. And it may be asked more broadly, to what end? Because of the cases, as your lordships will be familiar, which were brought before His Honour Judge Inglis at first instance as test cases, only 1 out of 10 succeeded. 3 were abandoned before the case started. 6 of the remaining 7 failed to establish noise-induced hearing loss, and Mrs. Baker, employed by the predecessors of Quantum, suffered, as the judgment said, having reviewed with care the evidence at paragraphs 192 to 3, only a slight hearing loss. And since the Court of Appeal concluded that even on the basis there was a breach of both statutory and common law duties, since it was only for part of the period for which the respondent was working for Quantum without hearing protection, that's between 1978 and 1989, the assessed sum that she was awarded on the contingency the Court of Appeal's decision was upheld was just over £3,300. Indeed, it's common ground, having read, as your lordships I know will have done, the respondent's case, that the injury identified has an incremental effect on the ordinary loss of hearing attributable to age, but on the respondent's own case, see in particular footnote 1 at page 7, it was only a minor one. It will only be sustained by those who have had long-term exposure, see paragraph 13 of the respondent's case, and in what's known as the Coles-Worgan classification, which is Annex 2 to the judgment of Mr. Justice Mustel, as he then was, in Volume 7, Tab 10, at page 453, and annex this judgment, loss of that kind is classified as being very slight. Now, my lords, none of us would wish to submit that hearing loss is in absolute terms in any way a trivial injury. It is an injury for which, if there is a causative breach of duty established, the law rightly gives redress. But in relative terms, and this will come to focus on the issue of reasonable practicability, compared with, say, blindness or loss of a limb, it must be at the lower end of the spectrum. So in short, what we say is if the Court of Appeal's judgment is upheld, one has the prospect of substantial litigation, of uncertain outcome, with an uncertain outcome leading, where it is successful, to modest awards. And above all, in our respectful submission, if the Court of Appeal's approach to what we would term retrospective standard setting is endorsed, there'll be implications in areas quite unconnected with Lloyd, where medical science identifies hitherto unrecognized causal links between known phenomena and injury. And I don't need to do more than remind your lordships of the illustrations given by Lord Justice Longmore in the Maguire case. So although we quarrel with many of the submissions of Mr. Hendy, not being premature, I hope, and Mr. Hendy in his printed case, one submission that we associate ourselves with is at paragraph 9, where he said, some of the issues raised in this appeal are of general application, touching on the application of protective health and safety legislation and the common law duty of care owed by employers to their employees. Now, in our printed case, we've set out, I hope, adequately the broad issues that arise. We do that at paragraph 5. And as my Lord in the chair has already observed, the court have appreciated from the printed cases that the three appellants and the intervener advance essentially the same arguments, albeit not in identical ways. So my role, as it were, is first in, if I may use on the eve of the Ashes a conventional cricketing metaphor, is to take the shine off the ball and allow my colleagues to score more freely when my innings closes, since we have on my right a very strong middle order. So I do have the advantage of a fellow opening batsman, my learned friend Mr. Nolan, who will share the burden with me in broad terms. I will deal with the issues of law, and he will deal with the issues of fact. Now, in order to shorten matters, we've sought to summarize in 2 pages the submissions that we intend to develop. And if I may have those now handed to the court, if that's convenient. And what we have done, I've referred, alas, anachronistically to the printed case references. It should, of course, be in contemporary parlance the written case, but that I don't think will in any sense aggravate or distract my lords. These are, in fact, able to be isolated from our printed case, but I thought it more convenient that the court could have an overview of this particular submission. And since, my lord, we are, as it were, in a public courtroom, perhaps I will be indulged just simply to read out swiftly what it is we are going to seek to develop. It falls into 2 parts. The first is the Factories Act of 1961 and the proper meaning of Section 29, subsection 1, and we develop 5 submissions. First, that Section 29 refers to the place of work qua place and not at all to operations carried out within the place of work. Secondly, Section 29 does not extend to atmospheric conditions at any rate to noise. Thirdly, the obligation to make and keep a place of work safe imports an objective standard, but one which must be judged according to contemporary standards and attitudes, and or, we use that connecting phrase, incorporates a test of reasonable foreseeability. 4, while it is for the employer to establish the defence of reasonable practicability, whether he has done so must be judged by the standards of the time and not with the benefit of hindsight. For it to be reasonably practical not to take a step to eliminate a risk, the time, cost and effort involved in that step must be disproportionate, but need not be grossly or substantially so. And then fifthly, the Court of Appeal had no basis for overturning the finding of fact made by the trial judge in the context of the common law issue, and of concluding that it was reasonably practicable for the first appellant to have provided ear protectors and any necessary instruction or training. And then turning more briefly to the common law position, the first proposition is the Court of Appeal was incorrect at paragraph 49 to interpret the judge as having held that for the average employer, the date of knowledge of risk of damage to hearing from exposure to noise below 90 dBA lec and the date for action were 1987 and 1989 respectively, that is to say prior to the 1st of January 1990, and was further incorrect to hold that under the common law test there was a breach of duty in such exposure prior to the latter date. Secondly, the Court of Appeal had no basis, and we refer to paragraph 109 of their judgment, for overturning the judge's finding of fact as the knowledge and understanding of the first appellants, and to substitute its own finding the first appellants had knowledge prior to the date of knowledge for the average employer, thus finding that the first appellant had the relevant knowledge in early 1983. Thirdly, the Court of Appeal had no basis for overturning the judge's finding that 2 years was an appropriate period for action by an employer who had such knowledge, and substituting in place of the judge's finding a period of 6 to 9 months. The of should be deleted. And fourthly, it was necessary for the respondent to show that if she'd been provided with hearing protection at the appropriate date and with appropriate warning, she would have worn it, and she did not do so.
Mr. Bellow, in relation to Factors Act,
Yes.
is there a trade-off between points 3 and 4? In other words, if you're wrong about point 3, does the concept of reasonable foreseeability become relevant under point 4 as part of the exercise of reasonable practicability? It seems to follow from the Court of Appeal's judgment that it does, because they do take a date in the 70s based on reasonable foresight or appreciation, at any rate, maybe.
Yes, your Lordship is absolutely right. I mean, our first position, our difficulty is that reasonable foreseeability comes in at the first stage of the equation, what's meant by a safe place of work. Alternatively, it comes in, or at any rate, additionally, it comes in at the second stage. And one will see how the courts, as it were, have varied in their attitudes towards that. But your Lordship's point to me is quite right, yes.
I mean, ultimately, depending on the width one is prepared to assign to the concept of reasonable practicability, it may not matter. I mean, I think the respondents certainly say it does matter, because reasonable practicability has a narrowness, and the Court of Appeal sought to identify what that was.
Yes, yes. Now, before I deal then...
But on your argument, does it make any difference? As long as you have reasonable foreseeability at one stage, does it make any difference?
Well, I wouldn't... I prefer to reserve the position that we should succeed on both. Can I just consider...
But I would be interested to know the answer to that. Maybe not.
Certainly a difference in relation to the burden of proof.
Yes, there's definitely in relation to that, there's no question. I mean, that may be part of the answer, in fact. Maybe
the whole answer.
If there's maybe a whole answer, I'll consider. For the moment, I'll take the half loaf and see if there's more that I can give to your Lordship at a later stage. Can I, before I come to deal specifically with those issues, just refer to two sections of our printed case where we deal, first between paragraph 12 and paragraph 47, with what we've termed background. First section dealing with workplace noise exposure and damage to hearing, and the second dealing with workplace noise exposure guidance and regulation. And we present it in that way because, regrettably, as your Lordships may already have noted, it was simply not possible, with the best will in the world, to have agreement on what were to be the statements of facts. And the statement of fact, the issues that was finally produced, your Lordship may feel was incompatible with the practice of this court and ill-designed for any understanding. And we felt the Supreme Court would be assisted by what we've extracted as to what we consider to be the minimum facts necessary for a useful overview under both headings. And since what's levelled against the sin of omission, not commission, Mr. Henley is, of course, free to redress the perceived imbalance in any way he sees fit. Now, my lords, I don't, again conscious of the time, simply wish to waste your lordship's patience by repeating what is set out in writing. And can I just say what are the basic conclusions that we wish the court to draw from the material that we have set out? It may be that in due course my learned friend Mr. Nolan will elaborate on these, but in respect of the first section, that's to say, noise exposure and damage to hearing, really there are 4 points.
That's paragraph?
That is paragraphs 12 through
12.
to 21.
Thank you.
There are 4 points that we would like you to bear in mind. Point 1 is that appreciation of the connection between hearing loss and noise came relatively late and was not the subject of any detailed research until the 1960s. Secondly, that predictably, once the connection was appreciated, attention focused on heavy industry, railways, shipyards and the like, which is in fact the context of the leading cases in this area, and not on light industry such as that in which Mrs. Baker, the respondent, was employed. Thirdly, that while research suggested methods by which a relationship between noise exposure and the expected incidence of hearing disability could be calculated, what it clearly and expressly did not do was to provide guidance on the duties of employers. If, for example, one takes the British Standard, 1976 British Standard, which we refer to at paragraph 19, and your lordships will find in the core bundle at volume 3 at tab 15. I don't need to read it to my lords. In the
15? Did you say 15? No?
Tab 15, 1-5.
Thank you.
What it says quite expressly is this is the science, but if you as an employer wish to know what you ought to do on the basis of this science, then you go to the code of practice. And then the fourth point, which actually is just an annex to the above, but the exposure of Mrs. Baker, the respondent, was at the lower end of the scale, as I say, barely over the 85 dBl LEC, which one finds in the judgment at paragraph 182. That's the judgment at first instance and not itself the subject of appeal.
Well, when the judge referred to the exposure between 85 and 90 rising, I think, not using his word, but exponentially, effectively, and when he then referred to the high 80s, he presumably meant 87, 8, or 88, 89.
Yes, in her case, we prepared to have the working hypothesis 86, so there's some argument as whether but it was above 85, but it was at the lower end of that segment. Now, on guidance and regulation, the next section, that is 21 through to paragraph 47, we make 6 points. The first is that the Code of Practice, the 1972 Code of Practice, current throughout the entire period with which the court is concerned, specified that where exposure persists for 8 hours in any one day and is to a reasonably steady sound, the sound levels should not exceed 90 dBA LEC. The core Code of Practice, which I'm sure you will have looked at already, is in volume 3 at tab 13. Secondly, second submission, it is accepted that in that document a distinction is expressly drawn between what is necessary and what is desirable, but in our respectful submission it is what is necessary which frames the appropriate test both at common law and under statute. The other phrase or the word used is acceptable, maximum acceptability, but it's the acceptability that we would stress. And of course there is in any walk of life a gap between what is on the one hand falling short of best practice and on the other actually committing something that could be classified as a breach of duty. Third point, the Health and Safety Report of 1975 on framing noise legislation, this is in your white bundle, at appendix 4, commented at paragraph 19, two comments of significance. Firstly, they commented there was a widespread recognition, not merely nationally, but actually internationally, as the 90 dBA standard. And again, in the same paragraph, paragraph 19, they recommended it as being, and I quote, the most practicable standard for future regulation. Fourthly, 12 years later, that is in 1987, the same august body, the Health and Safety Executive, was still contemplating whether, and again I give you the quotation, perhaps in the longer term, the 90 dBA accepted limit should be lowered. The reference for that is Core Bundle, Volume 4, Tab 23, page 25. Fifthly, the 1989 Noise at Work regulations came into effect on New Year's Day in 1990 and implementing a European Union directive for the first time provided for what was called first action level at 85 dBA LEQ, that action constituting giving advice on hearing protection. The provision of hearing protection was actually still, even then, to be made compulsory only for what was termed second level action at 90 dBA plus. And then sixthly, it was only in 2006, pursuant to a yet further European Union directive, did other domestic regulations make use of hearing protection compulsory for 85 dBA LEC and above. And what we are going to invite the Supreme Court to do is to draw to the conclusion from this regulatory history that the Court of Appeal's judgment simply did not synchronize with it. On the one hand, the course of regulation that shows that until 2005, the avoidance of risk at 90 dBA LEC and above was the objective. Avoidance of risk at anything below that had indeed been considered the subject of discussion and debate at European and national level, but it had not been embedded in regulation. Now, we accept in principle that it might be possible to reconcile the notion of criminal liability being engaged at a level higher than that which attracts civil liability, but our primary position is the regulations, in fact, set the appropriate stand for both. And what we do submit is, without prejudice that first submission, that it would be quite anomalous if someone who faithfully adhered to a code of practice was held to be civilly liable in respect of the very risk to which that code was directed in circumstances, as I say, where he did not depart from but actually implemented that code. Now, can I then, before I come to the particular sections, just deal with the overview? It is quite clear, of course, that the issue in relation to section 29.1 raises a question of statutory interpretation, and we've set out, perhaps gratuitously, the relevant rules that we say are germane in the first annex of our written case. Can I just make, as it were, again, summarise 5 propositions, all of which we say are relevant to this particular case, and then just illustrate 2 of them in particular with citation of authority which we consider to be helpful. First, of course, and classically, in interpreting the meaning of a statutory provision, it's necessary to consider the mischief to which it's directed as well as its literal meaning. cornucopia of references, but a speech of Lord Bingham was always illuminating and succinct in the Quantaval case, which we've cited. It's at tab 690, Strash 91, volume 691, at page 695 of the second volume of the appeal cases for 2003. Secondly, in determining what that purpose of a provision is, and what the mischief to which it's directed is, regard may be had to a variety of matters. Firstly, its enacting history, see Professor Benyon, volume 11, tab 5 at page 609. Secondly, within limits, which we recognise to what was said in the legislature, see again Benyon, page 217, volume 11, tab 6. Thirdly, we say to contemporary and subsequent official understanding of what the legislation meant. See in particular Benyon again at volume 11 at 7, and a decision of the Court of Appeal of Mr. Justice Brown Wilkinson, who then was in a case called Bilson in 1984 chance, which I may need to show to your lordships at a later stage. Thirdly, where the literal meaning of a general provision in an enactment covers a situation for which specific provision is made in the same enactment, it is to be presumed that the situation which was intended to be dealt with by the specific provision rather than by the general one. It's an elaboration of the old Latin tag generalia specialibus non derogant. Professor Benyon deals with that at volume 11, tab 10 at page 1164. Fourthly, that while we accept that a statute, and no doubt this statute falls into that category for the hypothesis in any event, a statute may be always speaking so that the basic concept may acquire a new content, the courts are not, however, entitled to stretch the basic concept beyond what Parliament intended. And then fifthly, there should be no assumption that the duty under section 29(1), if engaged, must necessarily be any more onerous than is subsisting duty at common law. Can I just track back to the fourth proposition and show you one case which we consider to be particularly helpful? This is in the first volume of Authorities, tab 14, a decision of the House of Lords in Birmingham City Council and Oakley. And this was a decision, an argument was about the reach of section 79 of the Environmental Protection Act of 1990, and the House of Lords held, with two dissenters, that it was held to be directed at the presence in premises of some feature in itself prejudicial to health as a source of possible infection, disease or illness, and did not extend, as the minority judges held that it did, to the layout of the premises. One sees the headnote epitomising the decision. Lord Hoffman, for the majority, in our respectful submission, said words of general application into to a statute of this kind. Mr. Straker, who was the person who succeeded in persuading their lordships on behalf of the City Council that the construction of section 79(1) should not be as large as Mr. Oakley, who was the individual contended. One starts at page 630, and Mr. Straker, appearing to the Council, says between B and C, the state of premises should be construed with regard to the legislative background. That is then spelled out in some detail. And at the foot of the page, the conclusion drawn from that survey is Mr. Straker is right in saying that the statutory origin of section 79, together with a separate statutory code dealing with toilet facilities required to be provided in dwelling houses, throw a clear light on what Parliament meant by the premises being in such a state as to be prejudicial to health. And he then refers to the jurisprudence suggesting that the absence of a facility, this is against C, or the layout of the premises, the absence of a facility such as a separate toilet, or the layout of the premises, so it's not readily accessible, does not mean that the state of the premises is prejudicial to health. He then refers to Mr. Sutherstone, as he then was, who appeared to Mr. Oakley, unable to show any contrary authority. And then this is the key passage, perhaps, a bit after E. Mr. Sutherstone argued that Section 79(1)(a) must be construed in the light of modern conditions. When it speaks of a state prejudicial to health, this does not mean a state which would have been so regarded in 1846. It requires the application of modern knowledge and standards of hygiene. The words must be construed as always speaking, in the sense used by Lord Steyne in Ireland. I quite agree that when a statute employs a concept which may change in content with advancing knowledge, technology, or social standards, it should be interpreted as it would be currently understood. The content may change, but the concept remains the same. And then he illustrates this. The meaning of the statutory language remains unaltered, so the concept of a vehicle has the same meaning today as it did in 1800, even though it includes methods of conveyance which would not have been imagined by a legislator of those days. The same is true of social standards, and then he illustrates this by Bill of Rights and the concept of cruel and unusual punishment. This doctrine, that's the always speaking doctrine at H, does not mean one construe the language of the old statute to mean something conceptually different from what the contemporary evidence shows Parliament must have intended, and then he goes on to give other illustrations to support that point. And the other point that I wish just to refer to authority, and I do it for this purpose, there have been statements in the jurisprudence relied on by Mr. Hendy, and they are helpfully quoted in paragraph 7 of his printed case, that the purpose of the 1961 Act and the predecessor provisions which it statute which it consolidated was to promote the health and safety of the employee. That much we can accept, but in our submission that provides no solution to the real question, was how far were they to promote it and by what means? And the heresy that one should always assume, as indeed Lord Justice Sedley appears to have assumed in this case, that the statute is an advance of the common law, it simply cannot be relied upon as being a general rule of construction. In the case of Bucks, which is in the second volume of our authorities, page 21, a decision of the Court of Appeal, one goes to page 1364.
Which tab was it?
This is tab 21. At letter H, the judgment of Lord Justice Stevenson, there is, in my judgment, my Lord's have it now.
No, did you say Lord Justice Stevenson?
It is Lord Justice Stevenson, yes.
1369.
1369.
9.
I'm sorry, yes, I misread name. H. There is, in my judgment, no presumption that a statutory obligation abrogates or supersedes the employer's common law duty, or that it defines or measures his common law duty either by clarifying it, or by cutting it down, or indeed by extending it. It is not necessarily exhaustive of that duty, or indeed, or coextensive with it. And I do not, with all respect to Mr. Stuart Smith's argument, think it possible to lay down conditions which is exhaustive or conclude it is so in this case. The statutory obligation may exceed the duty of common law, or it may fall short of it, or it may equal it, the court always has to construe the statute or statutory instrument which imposes the obligation, consider the facts of a particular case, allegation of negligent fact made by the workman, and then decide whether, if the statutory obligation has been performed, any negligence has been proved. So we are quite prepared to accept that, in any rate, in this instance, there are two obvious ways in which the statutory duty is distinct from the common law duty. The first being self-evident, that it's enforceable by criminal sanctions as well as civil sanctions. The second being, already pointed out by my Lord Justice Dyson, that it inverts the burden of proof in respect of something said prima facie to fall within the reach of the statutory provision obligation to keep a place of work safe. And no doubt in other circumstances it may be said that statutes are more precise, they add certainty, etc., etc. But the global notion that, as it were, a pro-employee interpretation is the only interpretation that is consonant with principle, in our respectful submission, is simply not to be made out. So finally, then, I come to the submissions that we have set out in the two-page document that I handed in to my Lord. And the basic submission is this, that in section 29.1, and perhaps it's useful now to have the Factories Act at one side, volume 10, tab 13, that its focus is on the safety of the place of work and not, other than consequentially, upon the safety of the employee. And obviously the issue is important because if, as we contend, the section which your lordships will find at page 17 of the Factories Act in that particular tab, if it's confined to place rather than the operations carried on within it, the respondent falls at the first hurdle. The second preliminary point we make is that there is no direct House of Lords or Supreme Court authority on its scope. And the third is we do want to take, and not only out of respect for my Lord Kerr, but we find it of general utility, two observations by distinguished judges in the Northern Ireland courts. If your lordships be good enough to take volume 8, and mercifully the two authorities are juxtaposed. The first I would go to is the judgment of Mr. Justice Carswell, as he then was, in one of a list of cases arising out of activities at Harlem's, the shipyards, Harlem and Wolff. 23. What, put it in the vernacular, Mr. Justice Carswell recognised...
So which tab is it?
I'm so sorry, tab 23, my
Thank
lord.
you. No,
Mr. Justice Carswell is tab 24. So, the next one I'll refer to is tab 23. And putting in the vernacular, what Mr. Justice Carswell recognised in his judgment at paragraphs 94 and onwards is that the law was in a tangle. So I could just start at paragraph 88 to identify the issue which he had to decide. Paragraph 88. The issue which arises is as to what extent it may properly be said the activities carried on in the place of work render that place unsafe for the purposes of section 30, subsection 1. Those are the Northern Irish analogues to the Factories Act. And he goes through certain of the cases, and he says at 94 then, I've never found the reasoning in such cases as the hearing loss decisions easy to accept in its entireties. Once one goes beyond the condition of the premises themselves, and that's where we submit one should stop, and admits the proposition that some types of activity on the premises can make the place of work unsafe, there does not appear to be any logical stopping point. it's been held in some of the decisions which I've cited, one has to have regard to permanently installed machinery and regular activities carried on in the premises in determining whether the place of work is safe. It's not altogether easy to see on what principle the activities should be restricted to those carried on regularly, or how the dividing line can be drawn between regular and irregular activities. Moreover, if one extends the ambit of section 30, subsection 1, at the analog of 29.1, there will be considerable overlap with many other provisions in the Factories Act, for example, sections 15 and 62, and that's another point, of course, that we make ourselves. On this interpretation, there'd also appear to be a large overlap between then certain regulations that are referred to, with some hesitation, therefore, and with deference to the judges who have decided to make the equipment and activities can make a place of work unsafe. I venture to suggest that the ambit of section 30, subsection 1, requires further consideration. And then he goes on to see whether throughout this tangle he can find a thread, and he does in the end allow for the sound of a caulking machine to in fact relate to the place, but as I say, he's obviously uncomfortable with the lack of clarity, and as he would see it, the lack of logic in those cases which have simply said the safe place of work refers to activities that are carried on rather than to structure and fabric. And if you go back to the previous decision, the decision of the Northern Ireland Court of Appeal, this was Lord Justice McDermott. There are just two passages that I'd like to draw your attention to. One is at paragraph 45, where Lord Justice McDermott says at the end of that paragraph, at first reading, it seems that place in section 27 more obviously relates to the fabric of the workplace rather than to the atmosphere within which the employee worked. And we would respectfully accept that proposition, and in our respectful submission, the first reading is in fact the best reading, and there's no reason to have trespassed outside that limit. And then at 49, although Lord Justice McDermott in the end was content to do that, he does say at 49, I accept that the application of section 27 to workplaces where there is no defect in the fabric of the workplace itself may lead to difficulties, but then in the end he says he's satisfied that the plaintiff nonetheless has established a breach in relation to the activities. But we say that firstly, that his first thought and reading is the correct, and secondly, that the very fact that a more enlarged interpretation leads to difficulties cannot be discounted in the way in which he did. So really then, can I come to the proposition...
So does that make his actual decision wrong?
We would have to yes, we would have to disagree with his actual decision.
And that of Mr. Justice Carswell?
And indeed that of Mr. Justice Carswell.
I thought Mr. Justice Carswell's decision was that...
it was in relation to vibration, my Lord.
That actually the place was not dangerous because the only danger was created by the machine brought onto it.
Yes. I mean, his observations about noise were in fact overture, but I mean, what we're saying is that he did find that in enlarging the concept of place beyond, he didn't find that it's altogether easy to reconcile, or indeed, as he put it, logical. And what we're asking logic to do is indeed to cut the knot and actually to restore the proper construction to what we submit it was always intended to be.
So it should just be the physical attributes, the physical dimension of the place.
Yes.
Mr. Justice Carswell's decision is based on the middle ground, isn't it? Unless the operation is permanent and continuous.
I know. Yeah. That again is but it's very uneasy terrain, we say. It doesn't give a proper purchase, which we say is only given by giving it. And our first proposition is, what is the ordinary and natural meaning of place? And we say it's equivalent in effect to location. The second proposition is there's nothing in the statutory context to give it a wider meaning. Can I just read to your lordship
Just
now?
before you do that, I mean, obviously, place can have a physical dimension, but it's a commonplace, is it not? That I shouldn't say commonplace, but it's unexceptional to describe a place by reference to attributes other than its physical dimension. To take one example, it's perfectly ordinary to describe somewhere as a noisy place, isn't it?
Yes, but in our respectful submission, the primary meaning is a physical location, and indeed, and that's what Lord Justice McDermott himself recognised. And what we say, because as your lordship is quite right, in the end this is a question of statutory interpretation, there is nothing in the statutory context to actually give it a wider meaning. Can I just read the section now? There shall, so far as reasonably practical, be provided and maintained safe means of access to every place at which a person has at any time to work, and every such place shall, so far as reasonably practicable, be made and kept safe for any person working there. Now, the qualification of place by the phrase at which at any person has at any time to work does not, of course, itself enlarge the meaning of the word place. Rather, it restricts it to a particular place, that's to say a workplace, as distinct from, for example, domestic premises. And we go further and respectfully submit that the qualification itself, and this is a partial answer to my Lord Kerr, recognises what we say is an elementary distinction between a place and what is done at it. The construction that we say flows from the language is fortified by three considerations, four considerations, one general...
Just before you go on to that, but Lord Justice Kelly's description of the purpose of the statute has to be rejected. The one in paragraph 49, the quote in paragraph 49.
Yes.
It says that it embraces all the dangers to which a workman may be exposed, which arises from the nature of his place, whether it comes from the physical structure or its condition, or from material operated in or processes carried on in the water.
We say
you
that
have to reject that.
Unjustified elongation. And as I said, I mean, one of the factors, although
they're all naturally features of the place, aren't they?
Yes. But one's got to look at this with respect in the context of other provisions in the statute to which I will come, and which I will say make it quite clear that unless there's a quite unnecessary degree of overlap between the provisions, that the natural meaning is the correct meaning. And I was just going to say there were four considerations. The first one is a general consideration that statutory provisions whose breach give rise to criminal sanctions should be given a narrow construction. The criminal sanctions for breaches of this particular provision is defined in section 155. The principle, it needs really at this august level no authority, but we've cited for convenience the judgment of Lord Justice Somerville, as he then was, in Franklin, and that's at volume 3, tab 46, at page 557 of the King's Bench reports for 1948, and indeed, of course, as Lord Justice Diplock, as he then was, made clear in a case called Taylor and Co. alike, actually it was judicial decision that these provisions gave rise to civil liability at all. That's the general consideration. The first particular consideration is that we draw your Lordship's attention to the fact that the obligation to keep and maintain the workplace safe was an additional obligation to that which was present in the 1937 Factories Act, which was to provide and maintain a safe means of access to the workplace. And we respectfully submit that in the former context, a safe means of access to every place at which a person has at any time to work, place must mean location and not the operations carried on at the location.
And where do we see section 37? Oh, sorry.
The Factories Act of 1937.
Yeah, do we have that?
Yes, you do. You want to remind me where I think it's in volume 9. I don't think there's any dispute about this, my lord. It was there in 19...
Yeah, well, what does it actually say? This is different. Section 29 is formulated differently, is it?
Well, it adds something. You can... Well, let's look, if your lordship. One would say, well... If one looks at 26, subsection 1 of the 1937 Act, that is in volume 9 at tab 10, one sees there shall, so far as reasonably practicable, be provided and maintained safe means of access to every place at which any person has to work. So as it were, first 2.5 lines stay in, and then added on originally in 1959, but consolidated into the 1961 Act, is the latter part of that subsection. That's to say, and every such place shall, so far as reasonably practicable, be made and kept safe for any person working there. So it's not, as it were, that the statutory language is different in the sense that the original phraseology is retained and there's been an added subclause. And what we say is, if one's talking about means of access to a place, one is talking about location and not physical activities, and we therefore submit that the added obligation ought, as a matter of language, to have the same meaning to be attributed to a concept of place as in the original obligation. The second particular reason, we ask your lordships to go to section 29.2 over the page of the 61 Act, where any person has to work at a place from which he will be liable to fall a distance of more than 6 feet 6 inches, then there's certain obligation imposed. And what we respectfully submit is that place in subsection 2 clearly is a reference to location and not to operations carried on at a location. And again, the submission is, if that be right, then one would logically interpret the meaning of place in 29.1 to the same effect. And then the third, and this is the answer to both my Lord Clare and my Lord Clark, when one's considering the question of statutory construction, one has to look to other sections of the Act. And we've identified in Annex 2 to our written case sections which would actually be quite unnecessary if section 29.1 was other than restricted to fabric or to structure. And we again rely for this purpose on the Bennian's application of the Latin tag principle generalia specialis non derogant. One sees, as we've set out, and I'll just list them, provisions made for cleanliness, overcrowding, section 1, overcrowding, section 2, temperature, section 3, ventilation, section 4, lighting, section 5, drainage, section 6, dangerous fumes, section 30, then removal of dust or fumes from the factory atmosphere, section 63, protection of eyes, section 65, and humidity of section 68. And what we say is, contrary to the argument that's ventilated or articulated by my learned friend, Mr. Hendy, in his printed written case at paragraph 76, that one should construe section 29.1 as a catch-all category to embrace everything, whether covered elsewhere or not. We say that does violence to the proper principle of statutory interpretation, that if one has particular provisions dealing with matters, in this instance atmosphere or other matters of that kind, there's no basis for saying that 29.1 embraces all those as well.
Well, just take lighting, for instance. I mean, surely if a physical place is dark, in circumstances where if it were properly lighted, it was not in any way dangerous, but it is made dangerous because it is dark and therefore somebody might trip over something or something which is physically there. Isn't the absence of lighting something which is relevant to and part of the lack of safety of the place?
I mean, our primary submission would be no, but if our secondary submission was, well, that may be just one illustration. But if that was so, to say, right, there are two routes in relation to that, non sequitur, that there are every other route is absorbed in that, because then they become effectively redundant, other than by, as it were, reinforcing a point said to be otherwise made.
Well, it's not unusual to have specific provisions which are, as it were, for the avoidance of doubt provisions, fleshing out the general duty.
Well, one can have those. We say that isn't so here. What we say is, I mean, there are perhaps two further general points to be made. The first is to identify the location of Section 29. If you go back to the first page of tab 13, you see that these sections have been arranged in a particular way. And what one has is part 1 deals with health provisions, part 2 deals with safety provisions, part 3 deals with welfare provisions, and part 4 deals with health, safety and welfare, special provisions and regulations. And we say with respect that noise itself would be considered ordinarily not to be a safety issue, but to be a health issue. And that's a reason, in our respectful submission, for saying that that doesn't come within the ambit of Section 29. The second is this. Parliament has presciently endowed the minister, again not unusually, with power to make regulations that are thought to be reasonably practical and to meet the necessity of the case for safety and health. That's Section 76. In fact, although certain regulations were made, the regulations that were made were entirely superseded or substantially superseded by the Health and Safety at Work Act, which was more general. So we say that that's where, as it were, in anticipation that there were matters that were not elsewhere covered, the Secretary of State or the then Minister had the power to make special regulations which would cover them. And as we've seen, as your Lordships will have seen from the printed cases, there are special regulations that were in fact meant to deal with noise, in particular segments of industrial activity. Now, my lords, what we've set out in our printed case, again, written case, at paragraphs 80 to 84, is what we term, as it were, 3 streams of authority. The minimalist approach, that's a place restricted to the premises themselves. The middle way, the place includes permanent equipment and constant, regular and recurring processes. And the maximalist approach, which includes processes without the qualifying epithets. And again, my Lord Clerk has helpfully reminded me that, in fact, Lord Justice Kelly, in that case, well, indeed, we refer to that expressly. That particular paragraph is a clear illustration of that line of thinking. And the existence of the controversy, we say, was noted by Mr. Justice Ashworth in the Berry case without seeking to resolve it. Now, my lords, Mr. Hendy, at paragraph 71 of his case, refers to a series of cases in which what I call the maximalist approach has been adopted, but that only, in our respectful submission, confirms that there are a variety of views. I mean, as many judges, as many opinions, top judices, quot sententia, one might properly say, in this context. And it is not useful, it may be for the court, to enter into the debate whether Mr. Hendy's cases are a river, are a trickle, or whether there is either stream is pellucid polluted or muddy or anything of that kind. What we do say is that as none of the cases, with one possible exception, are at this level, it's not fruitful to consider them, and time does not permit any detail. But I would like you just to look at Evans and Sant, which is the case where we respectfully submit the law took a wrong turning. And Evans and Sant is in 3-volume, 44 tab, a decision of the Divisional Court, presided over by Lord Widgery, then the Lord Chief Justice, and then Mr. Justice Bridge, as he then was, Vol 3, tab 44. No. And Mr. Justice Shaw, as he then was, forgive me for not recollecting that. The Lord Chief Justice, Lord Widgery, said this, having set out the facts and having set out references to certain predecessor regulations. At 635, at letter G, he says, I think the guiding light in our approach to the problem before us today is to say that in deciding whether the place of work was made safe, it is the place qua place that we look at, and not the place qua operation carried on at the place. That does not mean, of course, that in deciding whether the place is safe, one has total disregard for the activities which go on in the place itself. The safety of the place depends not simply on the construction of the floor and the solidity of the walls, but it also depends in some degree upon the nature of the operations carried out therein. Insofar as there is permanent equipment in the place, then its safety can, in my judgment, reflect on the safety of the place. Insofar as there are activities carried on in the place which are constant, regular and recurring, I can well see they may have their impact on the question of whether the place has been made safe. But whereas in the present case, you start with a place safe in every degree, and the only thing which renders it unsafe is the fact that equipment brought on it for a particular operation being used for a particular operation, a particular day, produces any danger, it seems to me it's not enough to justify the allegation, certainly in criminal proceedings. The place itself has not been made safe, and it seems to me if the justice instruct themselves, etc., they would have dismissed the information. So what he said was obiter. And of course the extensions he gives are those very ones that Mr. Justice Carlson then was said, why and on what, as it were, basis. And Mr. Justice Bridge, G, again recognises perhaps cautiously, he says, it seems to me clearly right that a line must be drawn, and then he says we're considering whether there's been a breach of regulation, between a danger on the one hand arising from the condition of the place as such, and a danger on the other hand arising merely from some activity carried on at the place in question. I should hesitate to attempt to lay down a comprehensive test to distinguish in practice between those two different situations. I can envisage great difficulties in relation to a particular set of facts in saying exactly where the line should be drawn and on which side of the line a particular case might fall. It must be largely a question of fact and degree. And then he said mercifully in the case before them there was no problem, because however one drew the line, the defendants were entitled to be acquitted.
But does Lord Widgery's articulation of the concept assist you here?
Well, the first part of his concept assists us, and the enlargement from the basic, it doesn't. Yeah. And what we're saying with respect is that this was in a case, and this was, as it were, the starting point of these general lines of authority, that there is just, first of all, it's obiter. Secondly, having started from a perfectly intelligible and we say correct point, he then diverts into something without, as Mr. Justice Carswell said, any explanation. And Mr. Justice Bridge, perhaps, is even more tentative, but he does recognise, as it were, that there is conceptually a dividing line. And in relation, I've already made my observations in relation to what I'd call atmospheric issues, which are catered for elsewhere in the Factories Act. But one asks again, the same philosophy. Why extend place even to machinery when there are other provisions which deal specifically with machinery? So
It may be prompted by considerations of common sense, because if you imagine two rooms in a factory hermetically sealed from one another, in one there is a minor defect in the floor which may lead to a sprained ankle, that's covered by Section 29. In the other, there's intensive noxious fumes which are highly dangerous to the individual. On your analysis, that's not covered by Section 29.
no, but it is covered by other sections.
Well, it may well be covered by others, but certainly, let's take noise. Intensive noise,
Yeah.
at, say, 180
Yes.
dBA. That's not covered by Section 29.
We say it isn't, no, and we say that at that stage, for reasons I'm going to develop with the assistance of my learned friends, it's quite clear that Parliament never had that in mind at the time, and of course, by giving the Minister power to make regulations, as it were, without necessary foresight, one just says, I can envisage circumstances in which it may be necessary to deal with a particular problem by regulations. That's what was dealt with.
Well, clearly, Parliament would not have had every form of activity in mind. That's why it was drawn in general terms, of course.
Right. Yes, but not so general that it wasn't thought necessary also to have a power to make regulations.
Yeah.
Can it be suggested that there is a difference in thinking of a different nature between the first two parts of the 1961 Act, the first part, sections 1 to 11, dealing with health, and the second part dealing with safety?
Yeah.
The first part deal with things which may affect your health over a long period, the possible exception being drainage of floors, which may lead to an accident, whereas the second part seems to be dealing with accidental matters which may give rise to accidents. And one of the problems in this case is that everybody, I think, accepts it would be perfectly safe to go into this factory space and work there for a number of years without any risk at all. It's only if you're there a very long time.
It's the temporal dimension.
So it's not just the nature of the operation, it's the nature of what the employee does in terms of staying at work in that place.
Yes. And that's why we respectfully submit, as it were, that one should, because of the existence of this temporal dimension, and not only the existence of a temporal dimension, that's to say the exposure has to be over a period that cannot be defined in advance, but that the employee has to be of particular susceptibility. That's again appears to be common ground on the findings below. So those are these two imponderables, and we again say it's another way perhaps of looking at the same issue. These are two factors that tend to suggest that one should concentrate in this area on what we say is the natural and ordinary, or at any rate primary meaning of the word place. Can we just say this? I mean, it's another perhaps thought that the common law, there's just two final thoughts before I come to the question of noise itself. The first is, of course, that the common law duty of care owed by an employer to an employee has a series of subsets, well-known: competent staff of men, adequate material, proper system of work and effective supervision, adequate plant and machinery, and then also, of course, a safe place of work. Now, all of them are under the same umbrella, but in our respectful submission, the jurisprudence has never found any difficulty in differentiating between those various sections, and the very fact that, for example, adequate plant and equipment is a separate subset from safe place of work, in our submission reinforces the point that there is no difficulty in confining place of work to its ordinary and natural and primary meaning.
Which is the power to make regulations?
76. We're coming to this. Yeah. Absolutely, we're coming to this. My Lord, there's one, as it were, postscript thought, which is this. It was found by the learned judge and accepted to be common ground that in this instance it was not reasonably practicable to reduce the noise of the machines, even assuming that, as it were, machines are to be factored into the concept of place. That's paragraph 69. The remedy that is contended for is the provision of personal protective equipment. And in our respectful submission, that provision obviously doesn't do anything to alter the workplace. It's not like, as it were, having absorbent materials on the wall. It doesn't actually do anything to alter the machinery. If one uses an extended definition of place, doesn't have silencers, anything of that kind. And we do pose the question, not merely forensically, how can a workplace which is said to be unsafe be made safe without altering it or even the operations carried out within it in any way? That was a question that was posed by Lord Justice Singleton, a case perhaps I should just show you, in Ebbs and Whitson 3/41, where he was construing, volume 3, tab 41, section 4 of the Factories Act of 1937, and the duty to render harmless as far as practicable all dust. And what he said at 194, at page 883 of the report, 1952 Two Queen's Bench report, which is tab 41 of volume 3. Top of the page, the only suggestion made by Mr. Edgedale, who appeared for the claimant, as to suitable protective measures was that the work people could be provided with gloves and ointment. The absence of such provision might be relevant on the question of common law liability, but I do not regard such a measure as coming within section 4, nor would it be rendering harmless the dust within the meaning of the section. Dust is not rendered harmless by giving the workmen ointment to put on their hands or covers. That may give them protection, but it does not render the dust harmless. And what the submission that all counsel have made on this side...
Well, I don't know about that. I mean, that seems very suspect to me. I mean, it might do, but that itself is a question of fact, isn't it? The ointment might entirely prevent your hands being affected by the dust, and then it would be harmless to the hands. So with great respect to Lord Justice Singleton, I wonder if that's right.
Yes.
It's a rather narrow view, isn't it? It's a somewhat...
Doesn't sound a very 21st century view to me, Mr. Bellow.
Well, I'm not certain that's, as it were, I don't think it's an anachronistic view. I mean, it's a view, actually, of what one perceives by the meaning of rendering something harmless. Does one actually have to do something to the it itself, or can one simply say one renders it harmless by providing protection which doesn't alter the it at all? That's the issue, and I think with respect it's nothing to do with the century or decade in which the question is posed. It's simply a question of how one ordinarily uses language. And for what it's worth, Lord Justice Sedley, who in the end was, of course, associated himself with the Court of Appeal in this case, he raised this very point at the outset of my learned friend Mr. Hendy's submissions. That you'll find in Core Bundle 2 at tab 7 at page 17, perhaps just to show it is not just Lord Justice Singleton some 60 years ago who entertained, as it were, doubts on this purpose. That's Core 2, thank you. It's tab 8, page 17.
I'm sorry, can I have the reference again, please?
I'm so sorry. My Lord, it is it's the Core Bundle, volume 2, my Lord, tab 8, at page 17. And one has the advantage of various extracts from the proceedings, mercifully not the entirety of the proceedings before the Court of Appeal. And in the middle of the page, one sees Lord Justice Sedley poses the question that does not seem to be an issue about the proposition that if Section 29 applies so that a workplace is unsafe because of ambient noise, making it safe can take the form of making the employees safe. Yes, Lord Justice Sedley, that seems to be accepted. Mr. Hendy, it does, there's authority to support it. On the face of it, it requires one large step. Yes, said Mr. Hendy, anyway, we'll come to that.
Sorry, which I beg your pardon?
I'm so sorry, it's page 17, my Lord, halfway down the page. Lord Justice Sedley raises the very issue which I've been addressing.
What's the top of the page start with?
Lady Justice Smith, the reference there to reasonable practicability.
Different page.
Do we not have numbers?
Must be later on in the tab.
Yes.
I think there are several.
Yes, I'm afraid that's right.
Oh dear, I'm sorry.
There's a later page 17 in the same
Well,
tab.
obviously, yes. Because this isn't, as I say, wholly sequential. It's fairly early on, as it were, the first set of pages which has a 17 in it. Yes.
On the right.
And you'll see that Lord Justice Sedley raises this question. He says there doesn't seem to be an issue about the proposition if it applies, say, workplace is unsafe because of ambient noise, making it safe to take the form of employee safe. Then the dialogue with Mr. Hendy saying, yes, there's authority for this. And Lord Justice Sedley says, on the face of it, it requires one large step. And really, Lord Justice Sedley, in a sense, in his question, epitomises our approach. We say that there is, under Section 21, a distinction drawn between, on the one hand, whether the workplace is safe, and on the other hand, whether the employees are safe. Obviously, if the workplace is not safe, the employees may not be safe, but it does not follow that everything that goes to making the employees safe, an absence of it, falls within the reach of Section 29.
Mr. Beloff, as I read the respondent's case, they say that there is House of Lords authority on this point. Ross.
Well,
are you going to deal with Ross?
Well, can I see how it's put? We actually say Ross is a place case as we read it. And I'd like, if my learned friend regards this as being, as it were, the high watermark of his case on this point, I'll see. But our short point is, yes, we have read him. We think it's a place case. Can I then come to the second head of the issue, which is noise? Again, assume we're wrong about the first, and assume that place of work and its safety embraces machinery and indeed extends so far as atmospheric conditions. We still say, in any event, noise falls outside it, and if we're right about that, that is also conclusive against the respondent's claim. So we make the following submissions, if we make, and this I can deal with relatively briefly. Firstly, there is no clear authority at this level to the effect that Section 29 applies to noise. Secondly, the statutory language indisputably makes no express reference to noise. Thirdly, specific provision was made, as I've already sought to illustrate, in the Factories Act of 1937 as consolidated into the Factories Act of 1961 to deal with atmospheric conditions. And those are the sections we've quoted, or contained in the sections we've quoted in Annex 1. Fourthly, we would submit a point I've already made, but it's relevant under this heading, that noise itself is a health issue rather than a safety issue. And yet one must note that Section 29 is no doubt by design located in a safety section in an Act which has clearly defined categories. Fifthly, noise-induced hearing was on the evidence, not in the contemplation of the legislature, when the 1959 amendment to the 1937 Act, which, as I sought to demonstrate to my Lord Clerk, was that which extended from safety of means of access to safety of place of work, or indeed when the consolidating 1961 Act was passed. And we've produced, if one looks at the summary in our written case at paragraphs 14 to 16, that seeks to elaborate that proposition. And then sixthly, a point that I think my learned friend, Mr. Lim, is likely to develop a little more. We say the circumstances of the enactment of the predecessor to section 29(1) and its latter clause, and the subsequent parliamentary proceedings at the stage either in 1959 or in 1961 simply do not suggest that atmospheric conditions generally, or noise in particular, represented the mischief to be addressed. And what is peculiar about my learned friend's submission is that if he is right, and if the Court of Appeal were right, to determine that noise actually fell within section 29(1), no one appears to have appreciated that was the case, and no one appeared to appreciate that what those who wish to reform the law regarded as a lacuna in the law had already been filled. Can I just give your lordships two examples only to make good that submission? The first is from the Wilson Committee, which is in the appendix part 2, at volume 3 at tab 25. It's not. Do you have it?
Sorry.
I'm so sorry, my lord, that there's a difference in reference between the... Is it the appendix part 2, volume 3, tab 25, the Wilson Committee? Can I, while that's being looked for, take you to find that? Give me volume 12. The Robins Committee later. Can you find it, guys? You found it? It's in this one. Which one? Yes, it's volume, it's appendix, forgive me, it's appendix part 2, tab 25. It's not found its way into the core volumes.
But you're right, it is the third volume of Appendix Part 2.
It is the third volume.
It is the third volume.
Well, there we are. I'm sorry, I was under that impression, but I was corrected. And what I'm looking for is paragraph 72.
Tab 1,
This is tab 25.
paragraph 72.
Yes, it's not paragraph 72. Is it 7? Forgive me. I apologise for this, as it were, interruption in the flow. Can we go to Robins while my learned friends see if they can identify this? This is the... It may be that we refer to it in our printed case. Just look at our printed case. The Wilson Committee said we need legislation. The Robins Committee report, this was what led to the Health and Safety at Work Act, and it reported in between 1970 and 1972. Are you looking for the printed case? Yeah, right. And one sees
Reference?
well, it's tab 17 of volume 12.
Tab 17 of
Volume 12.
12.
Volume 12.
Volume 12 of what? The authorities? Or
Of the authorities, yes. You found it. It is 726. If you look, noise is dealt with towards the conclusion of that report at page 109. at tab Roman 5.
I'm awfully sorry, Mr. Belfer. It's my fault, I'm sure. You said volume 12 of the authorities.
Yes.
And,
Authorities bundle, volume 12, official papers and parliamentary material.
yes.
Well, tab 17, I thought you mentioned, has Lord Robyns's report, but
Yes.
not the bit you're now referring to.
Sorry, yes.
And it goes far enough.
Which paragraph is it?
It's page 109.
Oh, I see. Yeah.
Yes. Actually, I can save your lordships the trouble of having to go back to the Wilson report in due course, because at 341, Lord Robyns and his colleagues refer to the Wilson report on noise, which dealt with the subject extensively, made recommendations about many aspects of the matter, including noise from aircraft traffic and industry. In the chapter on occupational exposure to noise, the report suggested that a hazardous noise environment existed in many industries, but that the existing knowledge of this highly complex problem did not provide a sufficient basis for legislation. And the reference I should have given, my lords, to the Wilson Committee report is paragraphs 534 and 726. 534 and 726, which is faithfully reflected in what Lord Robyns' colleagues and he say there. And that 345, having gone through, as it were, a development in the knowledge of the connection between noise and injury. At 343, the introduction of regulations to reduce traffic noise and noise from airports. At 344, that industrial noise had become a live issue in the field of compensation, and a first case ever given. And then at 345, he deals with, as it were, what should be done. And at the foot of the page, you see, further, we believe that the time is right to include basic requirements on noise control in occupational safety and health legislation. So this is all to do with the lex ferenda and not the lex lata. And the Wilson Committee and the Robyns Committee must simply have misunderstood section 29.1 if my learned friend's submission is in fact correct. And we say, in addition to the parliamentary illustrations that Mr. Lim will no doubt give to your lordship, that again, in our respectful submission, shows that the construction cannot be right. And then, finally, under this, the sixth general proposition, or perhaps their seven propositions, the sixth is that the Health and Safety at Work Act, which is in volume 10, tab 15, again, you needn't read this at the moment, it's fairly well known, I think, to my lord, it does add to the concept of protection against matters that would cause impact adverse on safety. It adds the phrase without risk, also without risk to health. So again, in our respectful submission, that was actually a conscious extension and not repetition, again suggesting that it was recognised that the previous legislation did not go perhaps as far as employees, and indeed persons not employees, were entitled to expect.
So the exposing the employee to a risk of excessive noise would be within section 3.
Yes, it would be. Yeah. And then the last point under this heading, and it's convenient that it should be, is this. There are, by reason of section 76, to which I've already referred, in the Factories Act of 1961, illustration in the authorities bundles of regulations made by the Secretary of State with, of course, parliamentary fiat. They are the woodwork machinery regulations, which are of 1974 vintage. They are SI number 703 at paragraphs, at volume 10, tab 73. We refer to those in our written case at paragraph 33. The agriculture tractor cabs regulations, SI 1974, number 2024, which one finds in volume 9, tab 1, and we refer to in our printed case, our written case at 34. The noise at work regulations, of course, 1989, statutory instrument 1989, number 1790, volume 10 at 16. And the general point we make is that all the making of these regulations would have been an otiose, an unnecessary exercise if Section 29.1 had indeed, as my learned friend suggests, responded in advance to the problems created by noise in so sweeping a way.
Now, these regulations are made under which statute?
They are under amongst others, under Section 76 of the Factories Act, as they make clear in their title.
No, the first one.
My Lord, I was then moving to, as it were, the third issue of construction that arises under the Factories Act, and that's the meaning to be attributed to the word safe. And perhaps, if I can just say what the submission is, if, contrary to our first proposition, the place is restricted to fabric and structure, and contrary to our second proposition, that the section extends to noise, the issue still is left outstanding. What is meant by safe in the context of Section 29? And what is indeed common ground is that it must be considered objectively, in the sense that an employer cannot rely dispositively on his own lack of knowledge of the risk. But what we say does not follow, as the Court of Appeal appear to have decided, that there can be defined once and for all time what is safe in any given context. And may I, if it's convenient, elaborate on that submission after the short adjournment.
Very well. I will look forward to hearing you again at 2 o'clock.